You're talking to your audience.
Okay.
Okay, I'm here with Ron Babase. I did pronounce your name
yes,
correctly.
Yes, you did.
And Ron has a long history of bringing awareness to the American public about the separation of powers. So I'll let him take it on the cue of separation of powers.
Okay, the Constitution was written to make sure that certain powers were separate, and the separation of powers were intended to make certain that no single same hands group controlled all government. That's why we have three different branches of government. We have the executive branch, we have the judicial branch.
Okay, I'm going to ask you to project because of this wind problem.
Okay.
So you're going to have to project, throwing your voice into the mic.
Okay.
And then we'll just start again on that whole thing. Go ahead.
Okay, so what we're working on is the separation of powers. The Constitution created three separate branches of government: the executive branch, the legislative branch, and the judicial branch. And the intent was that no same hands group would ever be able to control all government because of this separation. Unfortunately, over the years, the lawyers have managed to take over 100% of the judiciary branch, and they have succeeded in getting themselves elected in sufficient numbers to at least acquire a plurality of the legislative branch. There are more of them than anyone else in both the Senate and the House, and most often they are either the president himself is a lawyer or the people around him who influence him greatly are lawyers.
So what's the problem with that?
The problem with that is that when you have any single group that controls all government, it makes laws that benefit itself to the detriment of everyone else. And that is why Madison said we have to guard against any same hands group from controlling all government, and he defined a same hands group as a group that has an interest that is common to itself and different from everyone else in the country. And every profession has that, every trade group has that, and certainly the lawyers have that. Now, as a consequence of them taking over control, they have created on paper an excellent judicial system, but in fact, perhaps one of the very worst in the free world. And the reason is they control 100% of the judiciary. By controlling the rest of the government, they can pass any laws they want, and nobody as a group is in a position to stop them. The result of that is that we have lawyers able to do stuff to the rest of us that no one else can do, and that costs the country enormous sums of money. Now, injustice has flowed from that system for a very long time, and I wrote the continuation of the Federalist Papers to point out all of these things. I wrote that about maybe 15 years ago.
What are the Federalist Papers?
The Federalist Papers are the documents. There were 85 originally that Madison, Jay, and Hamilton wrote to explain the intent of the US Constitution in order to encourage the ratification of that. So when you read the original Federalist Papers, it explains all of these ideas about the separation of powers and why it was a good idea and why it was necessary. I wrote the continuation, another 22 papers, to explain that the lawyers had successfully destroyed the separation of powers, how they did it, why they did it, and why in fact many of them aren't even aware that they did it. Now, when I wrote that, I hoped that the country would become aware of it. The problem is the country is busy with all kinds of other things, and unless there is a lot of pain felt, there is not likely to be a good reaction. The problem is lawyers in control of everything have created a system that benefits them to the detriment of all others. They can sue anybody they want without a loser pays clause, so that essentially most of the time they can sue, win, lose or draw. They wind up not losing very much, and if they win a lot. That encourages them to sue all the time everybody, and that creates a situation which is very bad for the country. Now, I had said at the time the reaction will come when pain is felt by the people of this land. Now we are feeling the pain, and the pain comes from the problems with insuring health care. Health insurance in this country costs about 50% more to insure approximately 5% less people than anywhere else in the whole world.
Well, that's a huge statistic that could really affect this whole idea of providing a just and fair health care for the country, correct?
That's absolutely correct, and that is the reason why it is impossible to provide just and fair health care for the country, and I will explain why. The US already spends close to 17% of its gross national product on health care and only insures 85% of the population through insurance and Medicare. Now, Canada and Germany, who are the two countries that follow it in terms of the amount they spend per person, only spend somewhere around 11 or 12%. So we spend about 50% more to insure, about 5% less. Why is that? The answer is very simple. In this country, doctors are forced to practice what is called defensive medicine. Defensive medicine is not preventive medicine. It is not medicine done to make sure you don't get sick, like vaccines and recommendations what to eat and so on. Defensive medicine is intended to defend the doctor from the lawyer. And when the doctor defends himself from the lawyer, his concern is so great for his own economic survival that he will do whatever he thinks is necessary, not necessarily in the best interest of the patient, but to protect himself financially. It won't hurt the patient, but it will hurt the finances of the nation. So
how much would the nation save by fixing these problems with separation of powers?
Well, it is impossible to estimate with great precision, but the estimate that can be roughly done is this. If the nations of the world that spend the next highest amount only spend about 12%, that represents 5% less of the gross national product than anyone else. Now that 5% is roughly 750 billion with a B dollars. $750 billion.
Per year?
Per year. Okay? And that is an enormous sum of money. It's almost half of the current annual deficit. And that would be the long-term result. That is what this means. The lack of separation of powers has brought this upon us.
Okay, so the point is that if we correct this problem with separation of powers, then we would be citizens and government would be freer to create legislation at the legislative level to prevent, to be able to reform a lot of these industries, like the healthcare industry.
Yes, you see, the solution is to remove the power of the lawyers who run 100% of the judiciary from also having any power in the Senate and in the legislative and in the executive branch. To do that, it would almost be necessary to say that lawyers cannot run. Once they become lawyers and they become a part of the judiciary, they cannot run for these other branches. That would allow the other branches to do what's in the best interest of the rest of us. There are only approximately 1 million lawyers. They are less than 1/3 of 1% of the population, but they control 100% of the government effectively. And that is where the problem lies. If the legislative branch and the executive branch had no lawyers in them, there would be nobody to stop tort reform. There would be nobody to stop the doctors from being able to practice without the constant fear of economic disaster if a mistake is made not by the doctor but by the patient. If the doctor tells the patient come back in 2 days and the patient doesn't and then dies because he was negligent in coming back, some lawyer will sue the doctor, and some insurance company, just to settle and save money, will pay, and the doctor's life will be ruined because on paper it will look like he made a mistake when in fact the patient made the mistake. That is the essence of defensive medicine.
Well, okay. Now to play devil's advocate here, but there are some instances where malpractice is warranted. So how would you create a balance?
Well, the balance is created very simply. The people who are not lawyers will want the same kind of protection for lawyers in malpractice as they will want for other people. Everybody who is a professional of some kind has to take certain risks and has to cover those risks. Human error is something that happens, and malpractice of a doctor should continue to exist as an object of being sued for. But if the people who decide what malpractice is or is not are not lawyers looking to grab as much money as they can from the system, but rather non-lawyers looking to balance the interests of the aggrieved party with the costs to the nation, we will have a much fairer and just system. And that's what Madison wanted, and that was the whole purpose of the separation of powers. To make it simple, to understand it more simply, assume that doctors controlled the legislative and the government, and all governments except the judiciary. They could pass laws saying everybody has to have a checkup every year, and they could say the government will pay for the checkup, and they would say 300 million people must have a checkup every year, and then they could stand up and say we're taking care of the health of the country. The fact that the checkup would ruin the country, okay, is to their benefit and not to the country's. But
that's a very simple, wonderful solution. I have to applaud you for that. Now, also in the Obamacare, you have other problems, like you can't choose your own doctors, all done through the power of lawyers, through the legislature, and also the president, who's a lawyer as well. And also, if you reach the age of 70, is another issue. You become you're just described in the papers as a unit, and you don't get as much health care because you're 70, and I guess you're not. They would tend not to cover you
in the same way.
In the same way.
Okay, the problems. There are fundamental, basic problems, and then there are peripheral problems. Think of a building that is sitting on a basement, on a foundation. If the foundation is cracked, the whole building is going to begin falling apart, and the doors won't fit, the walls will buckle, all kinds of problems will occur. But correcting those problems in the long term does nothing. You must correct the foundation. The foundation problem here is that lawyers control all governments. All these other discussions that you're raising about what about this unit and what about this, that, and the next thing, all these things, none of them are 100%, shall we say, controllable, because the fact of the matter is, as we develop more and more science with regard to keeping people alive longer and longer, we have this conflict between the desire to do it and the impossibility of taking care of everybody in the country to the nth degree in terms of trying to maintain life. So that's always going to exist. The issue becomes, you can't discuss it rationally until you fix the problem. In the same way that if you live in a building and you're on the 12th floor, and that floor is beginning to have this buckling and the pipes breaking and the windows falling out, fixing it as long as the basement isn't fixed won't help. Now, when you fix the basement, you may still have some problems. Maybe you want to replace it with too expensive a window, you have to settle for something less. You may not have perfection, but you'll get a lot closer to perfection when you've removed the fundamental problem, which is the presence of lawyers in all government and their unconstitutional control of that.
Right. Now the healthcare Obamacare bill is this law that comes into effect, a federal law, for which states are in no position to, on a light challenge on a line item veto manner. For instance, a state has a right to normally to take portions of a proposed bill and say, and on a line item way, be able to make a decision based on that. So by taking the lawyers out of the legislature and putting it more into the state hands, would that be a good thing?
Yes, the issue you're raising, the Obamacare situation, is a simple one. Obama has decided with his people that he has the right to impose an obligation on the citizens of this country to buy health insurance. He says that he's given that right through what is known as the Commerce Clause. There are people who disagree with him, and if they do, there have been appellate decisions at the federal level agreeing and disagreeing with him, and it's going to go to the Supreme Court, and the Supreme Court will decide.
That did happen, though. They did, one judge somewhere, I don't know the details, did knock down his Obamacare on that issue.
On the results so far,
forcing people to buy health insurance.
Yeah, the results so far, one judge threw out the entire law,
right.
Another judge threw out parts of the law, a third judge threw out other parts, and so the matter is going to be decided by the federal Supreme Court of the United States in the end. You know, the interesting thing about Obamacare is some people say, you know, it does have some good things in it, and the point is, in every devil's brew, there are going to be good things. If I decided as President of the United States that I am going to give $1 million a year to every citizen, and somebody says, you'll bankrupt the country in 4 weeks, and somebody else says, hey, $1 million a year, that's a lot of good stuff. I like that. Isn't that good? Getting $1 million a year from the government? I'll be a rich man. So the point is, you cannot separate the good from the bad, as some people try with this Obamacare thing. The Obamacare is a package. Right. If it passes, it will destroy the country in many, many ways. It is very bad for the country. No question that if it passes in the short term, some people will benefit until the disaster hits everybody.
Okay, so so we know that elections are coming up for the presidency. And obviously all the Republicans steadfastly want to remove Obamacare. So what is your message to Newt Gingrich, Ron Paul, Rick Perry, and Mitt Romney, and their stance they should take now?
Well, I think that the Republicans have basically all said the same thing, and they have aligned themselves with what the country wants. They've all said they'll repeal Obamacare immediately, and or either that, or if they can't repeal it overnight, they will allow every state to opt out of it, which basically amounts to the same thing. So the bottom line on all this is the Republicans are very much in line with what needs to be done. And let's make no mistake about it. Obamacare is very nice if it were affordable. It's like that $1 million a year to everybody. It's a very nice thing, but it's just not affordable. And to implement it means that we won't find out in practice how bad it is until they have destroyed the country. That's what we have to avoid.
Okay, but you know that Newt Gingrich is a great fan of the Federalist Papers.
Yes.
Okay, and how should the Federalist Papers, in your line of reasoning concerning separation of powers, affect the platforms for which these candidates are taking for health care?
I don't see a direct connection, and the problem with my approach with respect to the candidates is that so many candidates, Romney is, I believe, a lawyer himself, there are so many people in the current political landscape who are themselves lawyers, okay, even though they may agree with my position, that it's difficult to get people who are in government to stand up and say, don't elect lawyers, because either they are lawyers themselves or there are other lawyers who are friends of theirs and they don't want to alienate. It's something the nation has to act on itself, or at the very, very least, make certain that every lawyer who runs or who is there now signs a pledge or a sworn statement to the effect that he will resign from the bar and never again practice law. That would help somewhat.
Yeah, because lawyers have taken an oath to the bar, which seems to supersede everything else they do. Is that correct? Or
well, the oath to the bar is supposed to be an oath of allegiance to the country and the rest of it. I think that's what it is. And I don't think
to the
that
Constitution, maybe.
To the Constitution, yeah. And the fact of the matter is, they clearly do not agree with my interpretation of the Constitution, although I have debated them repeatedly I've debated a lot. I've debated two people who were the heads of the bar on separate occasions, and all of my arguments have been presented to them in writing and otherwise, and I kept winning those debates until they refused to debate me anymore. So they are not on any kind of good grounds legally and theoretically, but they have the power of their position, and as a result they want to make sure they keep it, and they are not backing down, and they are not accepting my point of view, which is not abnormal. Nobody gives up power voluntarily, and they have the power, and the nation needs to become aware of it and do what's necessary to take the power away from them.
Okay, now you talk about that. What do citizens need to do?
Citizens need to become extremely aware of the fact that all lawyers need to be in the judiciary and the judiciary only. They need to also be aware of the fact that the problems with the health system stems directly from the lawyers' control of all governments, and as a result the defensive medicine that doctors are forced to practice and forced to deny they practice, because if they say that they're doing what they have to do to survive financially, they'll be sued for malpractice by other lawyers. So the bottom line is, the people of this land have to understand what's going on and do their best to correct it by voting non-lawyers into office and putting enough pressure on those who exist to create the tort reform that doesn't allow the kind of scandalous results that hurt everybody, including the doctors.
Okay, and the other power of the citizen is in the jury box, correct?
Yes, but that is a power that affects only a very small number of cases, and a lot of the jury nullification is what you're talking about. That's when the jury, even when the law is clear, they don't agree with the law, and so they vote in favor of what they think is right, and the judges and the lawyers hate that because it basically takes the power of the decision out of their hands and out of their interpretation. And so jury nullification has been around for a very long time. The judges tell you not to do it, the lawyers tell you not to do it. It's been done, and it continues to be done, but its impact is only very slight and only in very special cases.
But what if one of these cases concerning health care were put in front of a jury? Are they, first of all? I don't even know.
No. The issue of health, the fundamental issue of the legality of health care is going to be determined by the U.S. Supreme Court. All that will come before a jury is some minor issue of fact.
Well, right to choose your own doctor.
Well, the right to choose your own doctor is not going to be a justiciable issue in the way that you're suggesting.
Did the courts maneuver in such a way juries can't hear these kinds of issues?
Well,
at the trial court level.
Well, juries are not going to hear issues that have to do with the law. Whether or not the law of the Constitution of the United States allows what Obama is talking about is not something that a jury will hear. As a matter of fact, as I understand it, the states got together, and the state of Florida, I think the Attorney General called Bondi, is the one who went to court on that matter, but they didn't go to court on any specific issue of one particular person. The law hasn't even taken effect yet, doesn't take effect until a year or two from now. So they are arguing strictly on a legal basis that the law as written is not constitutional, and that is something only the U.S. Supreme Court can decide.
Well, that's beautiful, but it still gets back to the issue that why can't citizen juries hear these kinds of issues, one, and two, I know that the Florida state constitution doesn't give much leeway on the idea of being able to judge the law as well as facts, but the Connecticut constitution sure as heck does.
Well,
it says that the juries have a right to judge the law and facts in a case.
Okay, I'm not familiar with the Connecticut constitution. I believe that the juries in this state, and I think in most other states, are instructed by the judge that they are to decide on the facts only, and that then they must then apply the facts as they have determined the facts were to the law that is dictated to them by the judge.
But that's not right. I really must take a stand on this, at least in the state of Connecticut, because Article 1st, Section 6 states that the juries have a right to judge the law and facts of a case.
Okay, well...
Okay, so why... So that's illegal what the judge is doing as far as I'm concerned.
Well, if your constitution in Connecticut says that, then presumably the juries are permitted to judge the law and the facts. In most states, the point that is being made is that the juries are not in a position to judge or interpret the law. The people who write the law is the legislative bodies. The people who then explain to the jury what the law is and how it should be interpreted are the judges, and that's how it works. It is very.
I'm saying it's illegal, at least in the state of Connecticut.
Well, if maybe.
And also in the Federalist Papers, what does it say about that?
No, the Federalist Papers does not address the issue of the juries. There's never been an issue of the jury, any official stand, that I'm aware of, allowing the juries to make the determination as to what the law is. As a matter of fact, there's a very famous case, I think it was called Zenger, a couple of hundred years ago, where a guy got libeled, either libeled or slandered. Something was either written or said about him, which was perfectly true, but at the time the law said, even if it's true, you can't say that about a person. And the defendant admitted that he had said it. The plaintiff said, yes, it's true, but the law says he doesn't have a right to do it, and the jury acquitted. That was the beginning of jury nullification. The jury disagreed with the fact that a truth that had been disseminated either verbally or in writing should be punishable by a fine of any kind.
Okay, one last word on separation of powers, wherever you want to take it, and then end with how to go to constitutionalguardian.com.
Well, the separation of powers, the last word on it is we need to get the lawyers out of the executive branch and the legislative branch, and you'll find the Federalist Papers that I've written on my site called constitutionalguardian.com, or you can Google me, Ronald Bibace, B-I-B-A-C-E, or you can go to Federalist Papers and Google that, and you will find mine and the Madison Papers. And good luck to all.
Thank you so much for joining us today, Ronald.
My pleasure.
Thank you. That was absolutely excellent.
I'm glad.